Now, I am going to dictate the latest Supreme Court judgment, November 10, 2023, Mesa Sweta State Private Limited, Goregaon versus Haryana State Pollution Control Board and another, at the rate of 160 words per minute. Let's start. By this appeal, the appellant has taken an exception to the judgment and order dated 24th February 2020, passed by the National Green Tribunal Principal Bench at Delhi. The appellant undertook a project of developing a housing colony at Goregaon, Sohana Road, Sector 48, Goregaon, Haryana. The housing project comprised several buildings containing apartments, service apartments, etc. Initially, in August 2006, the appellant applied to the Haryana State Pollution Control Board for short the board for a grant of consent to establish CTE under Section 21 of the Air Prevention and Control of Pollution Act 1981 the Air Act and Sections 25 and 26 of the Water Prevention and Control of Pollution Act 1974 the Water Act to the board. The learned senior counsel appearing for the appellant urged that out of a total of 28 towers, 26 towers have been constructed. He pointed out that in 2010 and 2014 occupation certificates were granted for 9 and 10 towers respectively. On 24th May 2016 an occupancy certificate was granted with respect to 7 towers. He submitted that even assuming without admitting that the EC expired on 9th April 2012, renewal or grant of a fresh EC was not required as the superstructure of the building was complete before 9th April 2012, and for completing the further construction EC was not required in any event. EC was granted on 29th August 2017. The learned senior counsel urged that in any event NGT had no reason to deal with the controversy regarding the effect of the absence of EC, as the appeal was limited to the legality and validity of the order dated 15th March 2018, passed by the appellate authority. The learned senior counsel appearing for the appellant further submitted that once ex post facto CTE was granted, even if the appellant conducted certain activities before the grant of ex post facto CTE which required CTE, the appellant cannot be prosecuted, as in this case there is not a mere grant of CTE but the same will have retrospective effect. He would therefore submit that the input judgment and order is completely illegal. The learned counsel appearing for the board submitted that there was a specific condition imposed in the ex post facto CTE that as per the prosecution the approval order dated 21st June 2017 will be filed. He submitted that the appellant never challenged the said condition and therefore the appellant had no right to challenge the order dated 21st June 2017 approving the prosecution. He submitted that prior to the grant of the ex post facto CTE on 3 occasions the applications made by the appellant for the grant of CTE were rejected. He submitted that work of development cannot be carried out unless there is a valid and subsisting EC, and for a period between 9th April 2012 and 29th August 2017 admittedly no EC was granted to the appellant. He would therefore submit that no interference was called for with the impugned judgment. Firstly, we deal with the scope of the appeal before the NGT. The appeal was specifically for challenging the order dated 15th March 2018 by which the appellate authority set aside approval granted by the chairman of the board on 21st June 2017 to prosecute the appellant for the offences punishable under the Air and Water Acts. Therefore, the only issue in the appeal preferred before the NGT was regarding the legality and validity of the order of the appellate authority and the approval granted on 21st June 2017 to prosecute the appellant. While dealing with the appeal, NGT ought not to have gone into the issue of whether the EC granted earlier expired on 9th April 2012. Considering the limited scope of appeal, NGT ought not to have gone into the question of whether the construction carried out by the appellant between 9th April 2012 to 29th August 2017 was illegal. Stop. Thank you.